Shani Bar-Tuvia, who's a doctoral candidate at the International Relations Department at Hebrew University and a doctoral fellow of the Human Rights Under Pressure program, and she writes about refugee policy, and she's also been assisting Eritrean asylum seekers in Jerusalem, mostly with their asylum requests, for more than 3 years.
Thanks for inviting me and thanks for the introduction. So I'm here because of my academic hat, but actually chronologically and also mentally, for me, the activist hat, if it's okay to call myself an activist and to see myself as an activist, is more important. And chronologically, because I started volunteering before assisting with RSD, I was also teaching Hebrew to asylum seekers in Jerusalem, Eritreans and Sudanese, but yes, mostly Eritreans. And only then I slowly started realizing that this should also be my research area, because this is what I truly care about. And after this confession that I see myself first as an activist and only then as an academic, I have a second confession, and that is that I'm not a lawyer. I didn't do a bachelor's in law, and I come from political science and international relations, and I think, though, that my research, I know that my research is always on the theme line between law and politics, and the few points I want to make today, it's the same is true, because what other countries do or don't do, how countries interpret international norms, what are their policies and practices, this is the stuff that international norms are made of, and this is what I want to talk about today. My PhD project deals exactly with that, with the diffusion of restrictive refugee policies among Western countries, how countries are influenced, how they learn, how they legitimize their policies by referring to other countries. And I should start by saying that Israeli decision makers, when they keep comparing Israeli policies to policies of other countries, and they keep saying that nothing is new and everybody are doing that, they are kind of right. There is almost no policy measure that was implemented by Israel in the past decade against infiltrators, or what I call refugees. I even take it one step further than Anat, or the people I call refugees. There is not one single policy measure, or maybe, one single there is, but there are very few policy measures that are new, that weren't implemented by other countries in different versions. And that includes the pushbacks that Israel committed back to Egypt in early stages, and still today, every once in a while, the one-year deadline for applying for asylum, the geographical limitations on asylum seekers, so where they can go and where they can live and where they can work, administrative detention against those suspected in criminal act, and even the economic sanctions. And that holds true also to their recent deportation plan to Uganda and Rwanda. So the idea that you can take asylum seekers, in our case from Sudan and Eritrea, and just send them far away to a country that they have no link to, has been implemented by Australia. That's the only country that that is somehow comparable, this policy. So even this, when Israeli decision makers say that they are not alone, they are kind of right. After I said this, I want to convince you, with the time that I have left, that this is not the case, that the Israeli policies are unique, and for 4 reasons, or there are 4 aspects to this argument why the Israeli policies are still unique, even though when you take them separately, they seem to be kind of similar to other precedents worldwide. So the first thing is that there is no way to escape these policies. And what do I mean? Yes, other countries, they implement restrictive policies against asylum seekers, against failed asylum seekers, of course against people that haven't applied for asylum, etc. In Israel, there are no refugees. There are no refugees in Israel. The state comptroller published a report last week about the asylum system in Israel. 55,000 requests were filed since the Israeli RSD system was established in 2009. 55,000 requests, and 52 people were recognized as refugees. It's less than 0.1, as Anat said. And this point is especially important when it comes to those that are non-deportable, non-returnable to their home countries, or what Israel terms infiltrators. we know that only one Sudanese and 10 Eritreans were recognized as refugees during this more than a decade. So, and these are people that are not returnable. So Israel somehow recognizes that they are entitled to some international protection, and yet no recognition, so no escape from the Israeli policies. If we can point to other countries that also detain and deport and put geographical limitations, etc., there is escape from these policies. They are limited in time. And here we're talking about people that for 10 years, they're still living in legal limbo, deprived of rights. There is no way to escape this restrictive policies. So that's one aspect of why Israel is still unique. And of course it relates to the recognition rates. This was not yet mentioned. Compared with recognition rates worldwide, Eritreans in Europe, let's settle for Europe for now, are recognized, 90% of Eritreans are recognized as refugees when they apply for asylum in Europe. So it's pretty obvious that something here is weird, and I think this point is especially strong, which prompted the Ministry of Interior in the past few months to lie about that, and to say in every possible stage that these recognition rates in Europe, they are not for individual status, and these are simply lies. And I think it's interesting when high officials in the Ministry of Interior, they are lying. I think that, and of course citizens don't know that they are lying, but that's an important point then. If they are lying, it means that it's important. The second reason that I say that the Israeli policies are still unique is the small print. The small print is often ignored, and Cholot is a good example, because yes, there are detention centers around the Western Wall for asylum seekers or for failed asylum seekers, but they have a specific set of reasons, they are governed by certain rules that Cholot wasn't governed by. So if we accept that Cholot is a detention center, Israel confesses that, if we accept that Cholot is a detention center, then it is unique that you pick up people from the street after they were already out with visas, they were living for years and years in Israel, picked up, put in this detention center for 1 year, not because they are deportable, not because they failed their asylum request. It's just, so if you look at the small prints, that is not so small, then you cannot compare Cholot to other detention centers around the Western Wall. So that's just one example. The planned deportations to Uganda and Rwanda are a second example. Even the Australian case, we're not talking about deporting people to countries that they have no link to, after some of them 10 years that they have been living in Israel. So this length of time makes it extremely unique. Australia deports asylum seekers that just now arrived on boats. In Israel, this is not the case. We're talking about people that have been here for years, and this has also legal meaning. It means that Israel is violating Article 32 of the Refugee Convention. The third reason to say that Israeli policies are unique is that there are some policy measures that are really unique, that really have no equivalent in other places, and the deposit law is a good example and a very important one that I think we keep talking about deportation. I think that this is the real thing that affects the lives of asylum seekers right now, the main thing that affects their lives right now in Israel, and I was also not happy the day after the deportation was cancelled, and not because I'm an unhappy person in general. The four aspects that makes the Israeli scenario unique is the combination of restrictive policies. So yes, when you take each policy in isolation, you can point Denmark did that, Switzerland is also doing that, okay. But if you take the combination of the policy, you receive a very, very restrictive picture, especially when compared with the recognition rates, as I said in my first point. And the last point that I want to make is the issue of burden sharing. And that also it makes the Israeli case very unique because, as it was already mentioned, the border was sealed. There are almost no new infiltrators entering Israel since 2012. In 2017 it was 0, so none managed to cross the border with Egypt. And that means that Israel is not participating in the global burden sharing. I personally think that no Western country can use this excuse because 86% of asylum of people in need of protection worldwide, they are in developing countries. Only 14% manage to get to the developed countries. So no country can use this excuse, let alone Israel, okay? And even more so Israel. So these are the 5 reasons that I would say that the Israeli case is still unique. The courts, I will just quickly say, failed to, in general, it can be said that they failed to notice And I will only give the example of the transfer agreement. The High Court in Tegeta simply accept the state's definition of Uganda and Rwanda as third countries, and this agreement as safe third countries. But this practice, any of you that know something about refugee policies, safe third country agreements, it's something very specific, yes, very widespread in Western countries, and very different from what Israel was planning to do with Uganda and Rwanda. It's not the same policy. It's ridiculous to compare it with the Dublin regulation of the European Union or with the American-Canadian safe third country agreement. It's ridiculous, and yet the court accepted it and did it, and didn't see the uniqueness of this arrangement. I will stop here.